Good afternoon. I'm Dan DeRosa with 19 News, coming to you from our digital desk. We're about to take you live into Lorain County Court. You're looking at James Stewart Jr. He was convicted by a jury of 2 counts of murder, 2 counts of felony assault, and 1 count of illegal possession of a firearm in a liquor permitted premise. That means a bar. He was found guilty of the shooting death of Jason Kleinman, 49 years old, in a bar called Joker's Pub and Grub in Lorain County. I believe it's actually in Columbia Station. There was a fight that had broken out. Apparently, James Stewart Jr. pulled out a gun, and Jason Kleinman was actually trying to be a peacemaker in all of this. That's when James shot and killed Jason Kleinman. Today is sentencing day. Let's take you live into the courtroom.
You ready? Okay. We're on the record on 24 CR 111313, State of Ohio versus James A. Stewart Jr. This matter is set today for sentencing. Good afternoon to the parties, counsel, officer, Mr. Stewart. A pre-sentence investigative report was prepared, made available to the parties. Does either side, Mr. Pierre or Mr. Stepanek, have any issues or concerns with the preparation and reporting in the pre-sentence report? Is there anything that you wish to observe before it becomes part of the record? Mr. Pierre?
No, Your
Honor. Mr. Stepanek?
No.
Okay. There is a motion filed relative to the presentation of today's proceedings. I've talked to the attorneys, and we are going to proceed in the normal manner that this court does relative to sentencing. I would ask, well, actually would do more than ask, I would insist that you all continue to treat this matter with the respect that it deserves for both sides. And I will remind everybody that a decorum order is in place, meaning, and I'm fully aware of the emotions that this case has caused and for both sides and everything that's on the table here for everybody. To the extent I can, I get it. But I will not tolerate outbursts or any kind of improper conduct by anybody. At a minimum, you will be escorted out of this courtroom if there's a problem. And if it's serious enough or disruptive enough, you may be facing contempt. So please do your best to get through this difficult situation. Now, I have reviewed the state's sentencing memorandum as well as a letter from Mr. Stewart's, I believe, sister, Megan. So I've had a chance to review, I believe, all the material that's been provided to me. There are some folks on Zoom who are participating. I think they're muted, but they're certainly able to observe these proceedings and follow as well. Mr. Pierre, again, I always start with the state of Ohio. You have the burden. This is your case. You brought it, and I think it's appropriate for the state to proceed either through you in your office, Ms. Lee, or if there was a victim, I understand there might be some additional family members that are, or at least one family member that might like to be heard. So how would you like to proceed for the state?
We're ready to go forward, Madam.
All right, then you may proceed.
Thank you, Your Honor. Just some housekeeping matters. For the record, on or about October 15, 2025, an impaneled jury at trial found the defendant guilty of counts 2 and 4, which are both murders, unclassified felonies under revised code 2903.02B, and count 3, felonious assault, F2 under 2903.11A1, and count 5, felonious assault under 2903.11A2. As this court's aware, the defendant was also found guilty of 3-year firearm specifications under 2941.145, which were associated with each of those counts. The state has submitted in our filings our position that counts 2, 3, 4, and 5 are allied offenses. And for the record now, as the state said that we would in our filings, the state is electing that the defendant be sentenced on count 2, murder, a violation of 2903.02B, and an unclassified felony, as well as the appropriate firearm specifications as outlined for this court in the sentencing memorandum. It's the state's position that this court should go forward with sentencing specifically on counts 2 then and count 6 for, again, the reasons that we have identified in the filing.
I agree with that analysis, but any disputes with the merger of the 4 other charges?
No, Judge.
Very good.
Thank you, Your Honor. Moving on, this court was kind enough to receive the presentation of the victim impact statements of Jason Kleinman's parents, Nancy and Jeff Kleinman, on October 15th, 2025. They both at that time had the opportunity to read in open court written statements, which the state did attach versions of to the motion as State's Exhibit 1 and 2 to the sentencing memorandum. And the state asked on their behalf that this court take into consideration the statements that they had given on that prior date in your decision today. In addition to their statements, Your Honor, Tanya Von Dunn has voiced her desire to personally address this court at this sentencing hearing on behalf of the children she shares with Jason.
And would you like to hear? Would she like to hear from her now?
I would request that.
Okay. She may come up and make her statement. Good afternoon.
Good afternoon.
Would you tell me your full name for the record, please?
My name is Tanya Von Dunn.
You may proceed.
After sitting through this trial, I realized that people need to realize how one act of violence can change so many lives. On May 10th, I fell asleep on my couch. Around 11, my phone woke me to see Jason's ex-girlfriend calling. She never called me that late, so at first I thought she dialed me on accident, and I wasn't sure if I should answer it or not. But something told me to just answer it. That call changed my kids' lives forever and mine as a mom. Nancy, through tears, said, "I don't know how to tell you this, Tanya." And she continued on. "I'm so sorry, I don't know how to tell you this, but Jason is gone." I was totally clueless, so I asked her, what do you mean he's gone? Then she told me that Jason was dead. I was still not fully up, so I thought I must have misheard her, and I said, "What?" And she repeated that Jason was dead. I asked her how, assuming he was in a motorcycle accident, and when she went on to tell me that he was shot at Joker's. She told me that some people were calling her one of my boys' numbers so they could tell them, and she told them no, she would call me and have me tell them. My youngest wasn't home because he was at a friend's sleepover that night. So I called my mom and I told her what had happened and that I needed her to pick him up right away because I was terrified that they were going to find out by someone reaching out or on social media. I woke up my other sons and had them come downstairs, and when they were all together, I informed them that their dad was gone. They asked me what happened and I had to tell them that he was murdered. My one son tried leaving to go to the bar so he could see his dad, and I was fighting with him and trying to pull him back, telling him there was nothing he could do. I've seen my kids cry, but this was different. They cried in something I've never seen from them before. Just 1 second, please.
Take your time.
My heart broke that night, having to hold my children while they tried to understand this. I didn't know how they could possibly process this when me being an adult couldn't even wrap my head around it. Almost immediately, it was all over social media, with details no kid should have to hear. I replied to the post asking for some compassion, please stop, because my kids are going to see it, and it's hard enough for them as it is. By Monday morning, everyone in our town knew what had happened. I tried to have my kids go to school to have some kind of normalcy again, but when they went, everyone just stared at them, either not knowing what to say or telling they were sorry to hear about their dad. To put it mildly, they couldn't handle being in school. They couldn't even handle being around friends at that point. Talon's prom was the following weekend on May 18th. He no longer wanted to go. His girlfriend of 2 years told him it's okay, you don't have to go. And I told him no, that he had to and his dad would want him to go and try to have a good time. He went, but he couldn't handle being there, so the school let me pick him up. I tried everything just to get their minds off it, but nothing helped. At night, they would tell me the regrets and how they should have been better sons. One of my sons had some issues with his dad at the time and wasn't ready to talk to him about it yet. He now lives with regret that he never will. My other son said he should have made more time for him instead of hanging out with his friends, but he thought he would have more time with his dad. Another son blames himself because they knew their dad only stayed in Ohio for them. Can you imagine holding your child while they cry because if it wasn't for them, their dad wouldn't have been killed? It's unbearable. I now have 2 kids on anxiety medicine, one who refuses to take it and another who needs it to manage life still. Our youngest son still can't stay the night at a friend's house. Junior and senior years are supposed to be the best time of their lives before reality hits of becoming an adult, but not for our kids. When they should have been planning for college or after prom or gearing up for their summers, they had to agree if their father should be buried or cremated. 2 days after prom was Jason's service on May 20th. My kids have never lost anyone close to them. They've been very fortunate to have all their grandparents still alive. So their very first loss was their father. Their friends who have lost parents had time with their parents who were passing because they were sick. They got to tell them that they loved them one more time and see their faces. My kids didn't. I told them they shouldn't go to the casket because their dad was shot in the head. And they should remember him the way he was, not how he looked now. I will now question whether I told them the right thing to do for the rest of my life. 20 days after the murder was Talon's graduation. Talon didn't want to go. I don't know about you, Your Honor, but I can tell you that Jason and I had one kid we couldn't wait to see graduate. And at times we found ourselves questioning whether it was ever going to happen. But he did. And while he should have been so proud of himself and happy, he couldn't because it was just yet another reminder that his dad wasn't going to be there to see it. I knew commencement wasn't going to be great for Talon, so I asked the school if they could please make an exception and add to Talon's display some last-minute pictures with his dad so he could feel we did all we could to make Jason a part of it. They made the exception for us, and Jason's friends that I didn't even know showed up to support our son and represent his dad because he couldn't himself. Well, Jason is and will always be the main victim in this case. My kids' lives have been torn apart. I'm not telling you this for a harsher sentence because I raised my kids not to seek vengeance. Prior to the trial, we had more conversations than I can count about whether they should even attend the trial. I advised against it. I told them that it's going to be hard to sit there and listen to someone tell lies about your dad, and that it's more important to hold on to the truth than how you remember him. My one son refused. He said he needed to be there. I warned him that the defendant's family would be there too and that he needed to show some compassion for them because they didn't get a choice in this matter either. I told him, speaking from a mother's heart, that it would kill me to know that my son took someone's life and now his life will be ruined as well. He struggled to sit through the trial. Some days were definitely harder. He's now seen some things that no son should ever have to see, but he kept his cool. I can tell you that there is one thing that Mr. Stepanek and I agree on, and that is there are no winners. Verdict day, I talked to my son and I told him I didn't think it was a good idea for him to be there for the verdict. I was concerned he wouldn't be able to keep his emotions in check, and I promised him I would call him immediately afterwards. I texted all my sons after I left her courtroom, and I told them the outcome. My one son called me shortly afterwards and said, "Mom, I thought I'd be ready to celebrate, but I don't feel that way at all." And I told him that's because nothing has changed in your life, only the defendant's. I went on to tell him that nothing will bring your dad back, but at least you have some justice now, and to be grateful for that, because not everyone does. Jason and I chose to raise our kids in Olmsted Falls. They've never lived anywhere else, and that was our choice. Jason and I moved around a lot as kids, so we felt it was important for them to have a hometown where they were born and raised. Now their hometown is around the corner from where their dad was murdered, and it always will be. None of our kids care to live there anymore, and at one time that's the only place they could have imagined spending the rest of their lives and raising their own families. Every single special moment since May 10th is a lifetime reminder of what is missing. Holidays, celebrations, birthdays. Jason and our youngest son have the same birthday, so that just makes it even harder for him. Everyone in that bar that night experienced some kind of trauma from this act of violence. Some of them can no longer go to bars, some had to change careers, and others know how lucky they are that one of those bullets didn't hit them. Jenna, who took the stand and testified that she kicked the defendant out of that bar that night and was called a liar, still blames herself for Jason being killed, because if she didn't kick him out of that bar, he wouldn't have been there to kill Jason. I heard repeatedly that Jason was a biker during the trial, but that wasn't who he was. He was a son, brother, father, and a best friend to many. One of his friends shared with me after the murder that 5 different people came up to them and told them that Jason was their best friend. She reminded me that being a best friend takes commitment. It takes showing up when they're needed and being there throughout the good times and the bad. It's a lot of work with day-to-day life, but that's what he was to many. When our son was being bullied to the extent we were concerned he may hurt himself, Jason met me at the kid's house to talk to the parents. And when we pulled up, I saw there was a police car outside. When I asked Jason about it, he said he wanted to make sure nothing got out of hand. When I was diagnosed with a brain aneurysm, and Jason found out, he texted me to tell me he was sorry and asked if I needed anything. He offered to take the boys more and volunteered to have them stay with him while I recovered. And even after my surgery, he would text me to see how I was recovering and would reach out regularly to see how my follow-up appointments went. When one of our sons started making questionable decisions, Jason came over to our house and tried to scare him straight. It worked, by the way. When our youngest went into cardiac arrest and was rushed to the hospital, Jason immediately came to the hospital to see him and talk to the doctors to make sure every possible test was done. Most people don't know this, but my oldest son is not Jason's. Even his own friends didn't know it because to Jason, he was his son. So he never told anyone different. He chose to love him as his own, even when he didn't have to. That's who Jason was. He may have had a motorcycle and loved riding, but he enjoyed many things in life. Unfortunately, just not long enough. I stand before you because Jason mattered. His life mattered, and we want the court to understand what was taken from all of us can never be replaced. Everyone says that I'm happy it's over for you, but it's not. I'm sure there will be appeals, and then most likely the parole board hearings that will still be an emotional journey for everyone. So it's not over, but this is the only justice that we can receive. The pain doesn't fade, Your Honor. It just becomes something that the people left behind must carry with them every day. Thank you.
Thank you very much. Thank you very much. I appreciate your comments. Mr. Pierre, anybody else from the state or a victim or family that wishes to be heard?
Your Honor, I do not believe so. Just to wrap up the state's portion, Your Honor, obviously, Your Honor, you presided over this matter, over a trial that lasted almost 3 weeks, about 2.5 weeks. So this court has heard all of the evidence that the state presented and upon which a jury of his peers found him guilty of committing the offenses for which he is being sentenced today. On top of that, this court heard from the defense and the defendant himself when he took the stand. All of the evidence that was presented to this jury by which they made the finding that the defendant was not acting in self-defense on that night in that bar. On top of that, Your Honor, you've heard from the victim's family. Not just Tanya this morning, but Jeff and Nancy. And I know that this court has been practicing law longer than I have, but in all of my time doing this job, it is very rare to receive statements from victim representatives who have undergone such a loss and to hear a message of grace and forgiveness offered to the one who caused that pain. We'd ask that you consider all those things, but at the same time, Your Honor, we acknowledge that this court is limited in its discretion here because the statutes of the Ohio Revised Code are so clear here, and the state would submit that under the statutes that we have outlined for you in the sentencing memorandum, and I won't repeat here, that this court must impose at least an aggregate sentence of 21 years to life on count 2 The reason I'm emphasizing count 2 is I noticed that there was a typo in one of the headings of the sentencing memo that said count 1. I want to make sure that that's clear. And the state submits that it is in the discretion of this court to sentence Defendant Stewart to additional time on count 6 if it so chooses. Thank you.
Thank you, Mr. Pierre. Mr. Stepanek, Mr. Stewart, thank you for your patience. Mr. Stepanek, it's your opportunity. If you wish to say anything on behalf of Mr. Stewart.
Judge, I mean, I think you kind of know my feelings about this case, having heard the trial in chambers discussions about it. This is kind of a very difficult case, obviously. You know, I have no dispute that all the good things that Mr. Kleinman's family have to say about him are true and accurate in their relation to him and knowing them. As many people over my shoulder here that are supporting Mr. Stewart that have equally great things to say about him. This case has to do with these two gentlemen at a bar one night, this collapsing of time that is now defined two lives. This was an affirmative defense case, Your Honor. I know that the government had given you some a motion about Mr. Stewart perhaps expressing some frustration and things like that. And one of the things about that, Judge, you know, is that being in jail, the state of Ohio has the ability to access kind of your private thoughts. You can't speak to your mother, your brother, your sister, anybody without the government listening to every single word you say. So if you're very happy and excited about something, they know about it. If you're upset about something, they know about it. So that emotion happens in every single case. It's certainly not unique to Mr. Stewart. It just so happens that he's incarcerated, so the state gets to hear it.
Mr. Spang, I'm not holding anything against Mr. Stewart for comments he made. Today might be different because he's in open court and he'll be addressing me, but I'm not.
Right.
You know, I understand what you're saying, but I want you and him to know the comments he made in the privacy of that's not going to influence these proceedings.
Right. And well, I just wanted to point out, because Judge, I think part of the state's argument in their memorandum is that Mr. Stewart is not, expressing remorse. And I think that's difficult in a certain way when you have an affirmative defense case.
Well, I didn't mean to cut you off, but I was going to ask you about that because in the pre-sentence report, which neither of you took any issue with, in the attitude section, it does say the offender, Mr. Stewart, indicated he wished the offense never happened. He never wanted to hurt anyone. He feels terrible for the victim's family. But then the very next sentence says that he did not participate in the PSI interview. The offender did not show up for his jail interview. So I'm curious. I mean, I don't think the probation department would have put his remorse thoughts in there, but they also say he didn't show up. So I'm not sure how this came to be.
Your Honor, he must have shown up. He's in jail. So he did speak with them. I know that we had a conversation about his participation and wanting to a certain extent remain silent throughout these proceedings, knowing that an appeal would go on.
Sure.
I guess I'm just saying all that to the state's suggestion that he's not expressing remorse. I don't believe is accurate.
Well, there was argument in a brief.
Right.
But what matters to me is what happens in this courtroom, in open public, in front of everybody, so we all. I'm not going to put a lot of weight on legal arguments or what the attorneys say.
And I understand that, Judge, but I think in a typical case, it's difficult for, Mr. Stewart testified. And I had him testify, and I did not have him perjure himself. Everything that he testified to was his version of the events as he believed them to be still to this day. We did have a trial. We also had a lot of disputes as to what the jury instructions would have been, should have been. Those are very much in dispute. Those were hotly contested. Those are going to go to appeal. So it's difficult to a certain extent. It's not as if Mr. Stewart can say, oh, I'm sorry for factually and legally committing this crime as a normal defendant would in certain situations, if that makes sense to the court. He is certainly very sorry and remorseful for this conduct. This was a situation he wished he had never placed himself into, a situation that he wishes he would have been avoided. I don't think there's a day that has gone by that Mr. Stewart has not woken up and thought about this case and what happened. not only for himself and his family, but because there's some other citizen who's no longer with us because of what happened. And we had a trial to dispute the legalities of that, and the Ninth District will continue to look at that as well. So to the extent that he can be very sorry for what happened, he very much is. Mr. Stewart, you can tell from his pre-sentence report, does not have a record. He does not commit crimes. There is really only one factual dispute, I think, in this case, and that's whether he was drunk when this happened. The jury acquitted him of that. So, Your Honor, I don't believe that there is anything that Mr. Stewart can say or do to make any of this pain any the less. Everybody that knows him was very shocked that this would have been something that he found himself into. You could hear, if I could remind the court of the emotion that he expressed on his 911 call. This was not somebody who was angry and upset. This is someone who was scared and emotional, and that's the James Stewart that comes before you today. Has he expressed some misgivings about certain characterizations of himself even? Yes, of course. That's what trials do. I asked the court as well. I know that the prosecutor had, and I submitted a brief relative to this firearm specification. I think that the court is able to give Mr. Stewart 18 years to life. I do not believe that these firearm specifications need to be stacked. And I think the Ohio Supreme Court kind of gave us some direction on that very recently, perhaps unwittingly. So in this Bowler decision, they indicated that these firearm specifications need to be stacked consecutive. And that was a couple of years back. Most recently, this Logan decision emphasized what that actually means. And they specifically said that firearm specifications are not independent crimes. They are merely enhancements to offenses that people are convicted of. And that if the legislature wanted a sentence on a firearm specification alone, it could have done that. That's what it indicated in Bowler. So I believe that the Ohio Supreme Court has indicated that Bowler may have been incorrectly decided, or at least interpreted now a different way. So I believe that the court is entitled to, or empowered to, give only 18 years to life. And that is certainly no small sentence, Judge. This is a different case. The state had never, in any of our pretrial negotiations, we had never discussed any sentence other than a trial, basically. So that was the reason that we had this trial. There was never any other offer besides the indictment. So this is certainly not a lack of acceptance of responsibility on Mr. Stewart's part, other than the only offer that was given to him. I believe that a minimum sentence under these circumstances, based on this time that happened, is appropriate for someone without a criminal record under these circumstances as they exist. I'm not going to go over why this happened. The court's well aware. It's probably watched, this case more than any other case it has. But I don't believe that Mr. Stewart had any thought in his mind, especially from the evidence, that I'm going to, harm someone this night. This was a good night until it wasn't. This all happened in, shrinking time from the entire day that these individuals were together. You can take those 8 hours and shrink them into a minute. And they keep shrinking, and that's defining his life from here on out. So we look forward to the opportunity to have a different court look at it, appreciates the court's consideration in this matter, and ask that you give the 18 years to life.
Thank you, Mr. Spanik. Mr. Stewart, you also have the opportunity and the right, if you wish, to make a statement, recognizing you also have appellate rights, which I will uphold for you and enforce. I will not. Whether you wish to make a statement is entirely up to you. If you do, now's the time. If you don't, I won't take that into account either way.
I do wish this never happened. I wish I could change time. I was only trying to protect my brother. I know some words ring hollow, but I hope and pray for the best for his family. So.
Thank you, Mr. Stewart. A couple of quick housekeeping matters, and then we'll proceed. There has been brought to this court's attention the 5th District, and I apologize to the media, to the parties, the public. I've got to make a record. I'll be as brief as I can with these two legal issues. The first is the applicability of a 5th District Court of Appeals decision that came out about a year ago, finding what would be, in this case, count 6 unconstitutional, the illegal possession of firearms in a liquor establishment. The case is Stablehouse versus Striblin. It is a 5th District case, CT 2023-027. It is currently on appeal with the Ohio Supreme Court. The Supreme Court has not issued a decision yet, but essentially that in all of the counties that the 5th District covers, this particular charge is now unconstitutional, cannot be enforced. It's relevant for today because it's really one of the few areas that this court has discretion on. And the applicability of that decision to this case is precedential, but it's persuasive but not binding, meaning I don't have to follow the 5th District. We are governed here by the 9th District Court of Appeals. The 9th District is not opined on this matter. And at the risk of being critical of a court, which I probably shouldn't do, I am absolutely not going to follow this decision and find it ill-conceived and ill-decided. And therefore, the court will proceed to sentence on count 6. Conversely, this court raised the issue of the constitutionality of the stacking provision, which you both addressed. The General Assembly, the Ohio General Assembly passed a law some years ago, 2914B1G, that seems to have said that when somebody is convicted of only one charge, like Mr. Stewart, but has other charges that are merged or become part of that one charge, if those other charges have firearm specs, then the court has to sentence to at least one additional merged firearm spec. Now, this may be counterintuitive to some. After all, why should somebody be sentenced to 2 3-year firearm specifications for using a gun in one criminal act? The court, a few years ago, as Mr. Pierre and Mr. Stepanek indicated in its decisions called State v. Bowler, interpreted the language of that statute and said essentially that statute says what it says, and trial courts are required to impose at least one of the merged firearm specifications, even though Mr. Stewart won't be sentenced on those underlying charges. He's only technically been convicted of 2 charges, murder and illegal possession of firearm. And the legal possession of firearm does not contain a firearm spec, only the murder does. I take no issue with the Supreme Court's decision in interpreting that language, but that doesn't end the story. It doesn't resolve the conflict. The Supreme Court of Ohio did not test the constitutionality of that statute. They interpreted its language. And I agree with their language. The statute says what it says. I also believe it's grossly unconstitutional, unjust, and unfair. No citizen should be punished twice for the same crime. Mr. Stewart should be punished for murder, and he should be punished for using that firearm that night. But he should not, and in my court will not, be punished twice for the same offense. The United States and Ohio constitutions, in the due process clauses, in the substantive due process clauses, in other provisions, I won't bore you with all the details, primarily double jeopardy, prevent multiple punishments for single acts. And therefore, this court is declaring that part of the section facially unconstitutional, and I'm not going to sentence him to 2 firearm specs. Of course, the state has the right to preserve this decision and appeal it should they wish. However, I also find to get to the same place that the state wanted to get, the 21 years, is appropriate. The use of a firearm in this case, taking that gun into that bar for what was going on that night, is the worst form of the offense. And this case is very difficult to some extent for everybody. But it's not difficult for me because I have so little discretion, as Mr. Pierre and Mr. Stepanek pointed out. The only real discretion I have is to decide whether or not to impose a prison sentence on that illegal possession, and if so, how long, and should it run consecutive or concurrent, meaning at the same time. I believe, based on the nature of that particular offense, all of which could have been avoided in this courtroom, and the loss of Mr. Kleiman's life and the loss of Mr. Stewart's freedom, by not taking that gun into that bar. Or even more simply, when things started to go sideways that you sensed a little bit, Mr. Stewart, just leave. You're right. He has no priors. He's led an incredibly law-abiding life with strong family support, very low ORAS scores. And if I had more discretion, I might look at the case a little differently. But there's no question that the judgment you used that day and that night was horrible. And this was so, so unnecessary for that man to lose his life in that way. So the sentence is, I have to say some magic words and then I'll tell you how the sentence looks and then we can move on. The court has considered the entire record, the oral statements presented, the pre-sentence report, and the overriding purposes and principles of felony sentencing. Consider the seriousness and recidivism factors relevant to the offense and the offender and the need for deterrence, incapacitation, rehabilitation, and restitution. It's a judgment of the court and sentence of law upon consideration of all factors that a prison sentence is both consistent with the purposes and principles of felony sentencing and required under law on count 2. The defendant is not amenable to a community control sanction due to the seriousness of this conduct, its impact on the victim, and a prison sentence is reasonably necessary to deter the offender in order to protect the public from future crimes and will not place unnecessary burdens on government resources. The court will therefore sentence accordingly. And I'm sorry again that this is complex, but I have to make a record and be clear about what I'm doing so that the lawyers can correct me if I'm wrong. The 3-year firearms specification attached to count 2 will be served first, consecutively, and in full. That firearm specification is not subject to early release. Any early release mechanisms, judicial release, good time reduction. It must be served in full. You will not get credit towards jail time service towards that firearm specification. That will be followed by a 3-year sentence on the illegal conveyance. I am imposing the maximum 3-year sentence on count 6 to be run consecutive.
Illegal possession.
Illegal possession. I knew I'd be corrected soon enough. Legal possession of the firearm in that establishment. This court finds in imposing a consecutive sentence that a consecutive sentence is necessary to protect the public, punish the offender, and is not disproportionate. This court finds that that sentence was part of 2 or more multiple offenses in a single court of conduct using the weapon in that manner, and the harm was unusually great. Therefore, a consecutive sentence on that charge is appropriate, but there will only be 1 firearm spec. Once Mr. Stewart serves the 3-year firearm spec followed by the 3-year illegal possession charge, he will then begin serving a life in prison term. He will be eligible for consideration by the Ohio Parole Board after serving the first 2 sentences followed by the 15-year sentence. And as I think a family member pointed out, the Parole Board will address that issue down the road, and both sides will have an opportunity to appear before the board and make whatever arguments they feel is appropriate. Somewhat ironically, the count 6 illegal possession charge is subject to good time reduction and earned credit, so you can actually reduce that sentence in part with good behavior in the institution. I do not need to discuss post-release control because post-release control is inapplicable in a life count. If you are released, you'll be released on parole with the Ohio Adult Parole Board. I also understand, Ms. Lee, Mr. Pierre, that the family is not requesting any sort of restitution in this matter. Is that still the case?
That's correct.
Okay, so there'll be no restitution ordered as part of the sentence. The court will instead order the cost of the prosecution of this matter only, Mr. Stepanek being private counsel. Now, before I address appellate rights, is there anything I missed, Mr. Pierre, that you want to address? Anything I'm not getting straight.
Thank you, Your Honor. May it please the court. If the state would simply ask, and I know the court will allow us to make our objection on the record regarding the stacking spec and the specific statute that we've cited, 2929.14B1G, for the reasons we've already stated in written filings. We just note our objection so that when that appeal comes, that all parties understand that it will likely include a cross appeal from the state.
Absolutely. Your objection is noted. Anything else you want to address?
Yes, Your Honor. Finally, the state will be submitting to the court a forfeiture entry. To remind the court, there was a forfeiture specification regarding the Heckley and Koch BP9 handgun serial number 224-243-635.
I think I already signed it. I think you provided it without objection by Mr. Stewart and Mr. Spanik. You provided it to me, and I already signed the forfeiture.
Wonderful. Thank you, Judge.
I also should point out for the record, and I briefly mentioned this, I did review Ms. Megan's letter to me, and I appreciate her. I don't know if she's present or not, but I do appreciate that she wrote a heartfelt letter about Mr. Stewart. So that is part of the record, and I appreciate that I did. I want you to know I reviewed it as well. All right. You have a right to appeal. The right to appeal will be provided to you. Appeal will be filed timely on your behalf if you wish. You have 30 days from today to file that appeal. If you miss that deadline for some reason, you'll have to seek leave with the 9th District to appeal. If you can't afford an appeal, we will provide attorneys and all the documents necessary for you. We will also make sure an appeal is timely filed, even if you choose to hire your own attorney. So my first question I'm pretty sure I know the answer, but I'm going to make a record. Do you wish to appeal in this matter? Okay. Do you intend on hiring your own attorney, or do you wish the court to retain an attorney for you?
Your Honor, I've been discussing with him and his family the possibility of hiring an attorney. I'm going to remain on to make sure at least the notice gets filed, and we'll address if anything different happens within the 30-day period.
Okay, so if at some point you decide that you need the court to consider appointing an attorney, you need to let my office or let me know that, or Attorney Stepanek will let us know, because you need to fill out a financial affidavit that I have to review, and then we would consider appointing an attorney for you. But for now, Attorney Stepanek, I appreciate that you're going to remain counsel of record for the purposes of an appeal, correct?
Yes.
Okay. Michelle, for sentencing entry, do you have what you need?
I do.
Mr. Pierre, I'll ask one more time. Anything I missed or anything you want to address from the state or the victim's family's perspectives?
Nothing further.
Mr. Spanik, anything I missed from your perspective or Mr. Stewart?
No, Judge.
Mr. Stewart, good luck to you going forward. Thank you all so much for handling this very difficult case in the way you did. I truly appreciate everybody's participation, and I really appreciate how you've all conducted yourself. Thank you so much. We're in recess.
Dan DeRosa with 19 News. I believe my ears and my math were correct, that you're looking at James Stewart Jr. heading off to prison. He gets a sentence of life in prison with the first chance of parole at 21 years. That's, it can do the math for you here. The judge sentenced him to life in prison, first chance of parole at 15 years. He then gave him 3 years for a firearm specification. That means he used a firearm in the commission of a crime. He then also got 3 years for having a gun in an alcohol premise, a bar, for having a gun in a bar, of which he said he had to serve those consecutively and before the life sentence. So 3 years, that's 6 years plus the 15. It appears that his first chance of parole will be at 21 years. We will have a complete wrap-up on this and all of the day's news, and of course, First Alert Weather when we start 3.5 hours of news and weather at 3 o'clock on Channel 19. Until then, I'm Dan DeRosa with 19 News. Have a good afternoon.